Thank you so much. Let me make sure that this is on. Is it? It is. Now it is. It's a pleasure to be here. I want to thank the Academy. I want to thank the university for helping us to establish the Academy, to thank the colleagues who volunteered their time to make it work and the staff that supports them. I want to thank especially Paul Beck, who made a special effort to accommodate my calendar when organizing this fall's speaker series. Because of a little bit of IT problems, I'm going to be moving back and forth from the podium to the computer to move along the slides that I've arranged that I hope will help illustrate some of the things that I want to say today. So it may be not as smooth as many of the talks that had been my pleasure to see here. Let me begin with some background to my project of recovering the history of of constitutional politics in the United States. When I earned my PhD in American constitutional history and came to Ohio State almost 50 years ago, I was unusual in that I had actually attended law school for a year as part of my training. At that time, constitutional history had been written mostly by historians rather than by members of law school faculties. And while legally knowledgeable, a few of those historians had actually been legally trained. Now, it was no accident that I took law classes as part of my graduate training. I entered graduate school at the height of the Warren Court era. A constitution that the courts had made a bastion of conservatism had become a bastion of economic and social liberalism. The Warren Court's decisions not only put the Constitution squarely on the side of the growing civil rights movement, it knocked the constitutional pins out from under McCarthyism. It recognized freedom of expression and privacy as core constitutional values. It reconfirmed the broad power in the federal government to regulate the economy, and altered the political landscape by mandating that legislative districting respect a principle of one person, one vote. The role that the Supreme Court played in this constitutional transformation confirmed the centrality of that court, and courts in general, to the American constitutional system. It convinced liberals and progressives who've been very suspicious of the Supreme Court's role in the American constitutional system. It convinced them that the core values of the Constitution were under the special protection of the Supreme Court, which must have the final say in interpreting them. This is a kind of illustration that you'll find online nowadays. It's a stock photo from the Almy Company. I didn't bother to pay them for it here. But you can see that it's we the people, the preamble of the Constitution, is then superimposed on the Supreme Court building of the United States, which then is superimposed on that, of course, is the scales of justice, a symbol of legal activity. And it shows the common feeling we have today that the Supreme Court is really central to the constitutional system. In the decades since I took my year of law school, constitutional history, in fact, has proved far more attractive to law professors than to history professors. This focus on the courts, especially the Supreme Court of the United States, as the main site of conflict over the Constitution is reflected in current journalism and political analysis, as well as in most constitutional analysis coming from law faculties. And the present struggle over Supreme Court nominations is so intense because we live in an age when the justices claim, and most Americans seem to concede, that the Supreme Court has the ultimate say in deciding what the Constitution means, and therefore what it commands and forbids. Judicial supremacy is legitimated by the idea that constitutional law lies outside of politics. In this view, the considerations that go into legal analysis are different from those that determine political outcomes. The legal process is distinct from the political process, and judicial independence insulates judges from political pressures. And the common view, especially among lawyers, is that the judicial branch of the government sets the constitutional boundaries within which the political branches can act. Within those boundaries, politicians can do whatever they think the public welfare requires, influenced by the constellation of political forces to which they respond. When they transgress those boundaries, the courts are there, or should be there, to stop them. Members of Congress and the President are obligated to obey the Constitution, but that means the Constitution as the Supreme Court has interpreted it. Now, events have been dissolving this stark distinction between politics and law. It now seems commonplace to acknowledge that justices represent different political and constitutional philosophies. And that the political system plays a role, now more explicitly than ever, in determining which philosophy will prevail. But choosing justices who reflect a particular constitutional philosophy depends on gaining support for that constitutional philosophy. So there is renewed attention to the articulation of constitutional issues in the public sphere and in the non-judicial branches of government. Constitutional historians, many of them now lawyers, now speak of constitutional regimes of which courts and their decisions are a constituent part, well within the political system, rather than outside of it. But the obvious relevance of this notion to recent American politics is still only dimly understood by journalists and political pundits, and I dare say by most historians, who still focus on the Supreme Court as the final arbiter of disputes over the application of the Constitution to American life. Now, Salmon P. Chase, he hated his name, by the way, spelled like the fish, S-A-L-M-O-N, named after an uncle who was an influential lawyer in Maine. He wanted to be president, and is not a good president's good name. Salmon P. Chase began as an ambitious young lawyer. I do have a picture of him at an earlier age, or entering middle age at this point, receding hairline. He began as an ambitious young lawyer who, a few years after moving to Cincinnati, more or less fell into defending fugitive slaves and abolitionists in court. In the process, he urged state and federal judges to interpret the Ohio Constitution and the Constitution of the United States in ways that promoted freedom rather than the property rights of slaveholders. The Constitution, he insisted, was designed to carry out the principles of the Declaration of Independence, to create a government that would protect the natural rights of all human beings to life, liberty, and property. The framers, when they framed the Constitution, conceded the right of the states to establish slavery by positive law. But the concession Chase insisted was minimal. Slavery was a state constitution that had nothing to do with the federal government that the framers created. Chase's slogan became slavery local, freedom national. He cut his teeth in the anti-slavery cause by arguing that the Fugitive Slave Clause of the Constitution required only that states return fugitives from bondage to their owners, with the states having the obligation and responsibility of deciding how to do it. That clause, he said, did not authorize the federal government, which was, after all, dedicated to freedom, to do the job itself. It delegated the job to the states. Therefore, the Federal Fugitive Slave Act, he argued, was unconstitutional. He lost. State and federal judges, like most Americans at the time, interpreted the Constitution as a bargain by which Americans secured a stronger union with a stronger federal government in exchange for guarantees that this stronger union would protect rather than threaten the property rights of slaveholders. Chase believed deeply that his interpretation of the Constitution was right and that the judges were wrong. He believed in the rule of law. But that meant accepting the outcome of each case, It did not mean that judges had the final say over what the Constitution meant. Upon questions which partake largely of a moral and political nature, he told the Supreme Court, the judgment, even of this court, cannot be regarded as altogether final. The decision must necessarily be rejudged at the tribunal of public opinion. Chase lived in an age when constitutional politics took priority over constitutional law. He knew that constitutional issues were not reserved to the courts. And anyone who looks at antebellum congressional debates will be struck by that reality. As a constitutional historian who studied them has observed, virtually everything discussed in Congress became a constitutional question. From great controversies like those over the National Bank and the president's removal power to ephemera of exquisite obscurity. That's why so many congressmen were lawyers. Over 50% throughout the 19th century, over 75% during the Civil War era. Congressmen themselves pleaded cases. Well, before I say that, let me point this out. This is a drawing, contemporary drawing, of Henry Clay addressing the United States Senate. Notice the setup. In those days, when you referred to Mr. Speaker, and we still do today if you're in Congress, you are technically addressing the Speaker. In those days, you really did address the Speaker. You faced the Speaker. You didn't, as we do today, turn out to the rest of the Senate. The Speaker was rather like a judge. He maintained order and decorum in the institution. The senators, even though they themselves would take Clay's place and address the presiding officer, the senators were jurors who would decide on the persuasiveness of the argument and who was right, who was wrong. It's a court-like atmosphere. So, the lawyers who made most of these debates themselves pleaded cases before the Supreme Court, often on the same constitutional issues they had debated in Congress and with the same arguments. When the issues were important enough, they published their oral arguments and broadcast them to the public. Broadcasting actually comes from a mode of sowing seed, where you simply toss the seed on fertile soil and it grows. They were broadcasting their arguments, sending pamphlets out through the new modern systems of a new postal service that reached the whole country, which was largely used in its early days to transmit newspapers and pamphlets, not private correspondence, in a modern environment where you could address the public through these methods. Constitutional debates did not take place only in Congress and the courts. Newspapers, pamphleteers, speakers, and resolution committees at public meetings all weighed in. Politicians made constitutional arguments in stump speeches from the hustings. Constitutional issues were central to partisan politics. The Democratic Party restated its commitment to state rights, strict construction of federal power, and constitutional opposition to national banks, protective tariffs, and federally funded internal improvements in almost identically worded planks in its first 5 national political platforms. The first 5 planks were all the same, and they all said the same thing about strict construction of the Constitution, state rights, and limited federal power. Nearly all the newspapers were explicitly partisan in those days, and the Democratic ones hammered the party's constitutional principles home in editorial after editorial, blasting its opponents as representatives of hated federalism, meaning centralizing big government constitutional principles associated with John Adams, Alexander Hamilton, and their intellectual descendants. Whig papers, the opponents of the Democrats in those days, on the other hand, blasted the constitutional usurpations of aggressive Democratic presidents who followed the example of the despotic Andrew Jackson. This was an illustration, a graphic handout, broadcast to people around the country, and especially to ordinary people. Of course, it was elites and people with an intellectual bent who read the pamphlets, but ordinary people listened to the stump speeches and looked at illustrations like this that made the point. Andrew Jackson, born to command, King Andrew I, stomping right here, you can't read it, but it says the Constitution of the United States. Below him, having thrown down the reports of the Supreme Court because he ignored the various decisions of the Supreme Court that said, for example, that the National Bank was constitutional. He vetoed it anyway. And of course, he also was the founder of the spoils system, using his powers as president to staff the public civil service with political supporters. And they list the things that make him a king. The idea, of course, vote for the Whigs. Stump speakers echoed the themes. John A. Bingham, the author of the first section of the 14th Amendment after the Civil War, recalled that his first political experience was a debate in which he accused President Martin Van Buren, Jackson's successor, of constitutional usurpations. Almost everything was reduced to a constitutional question in those days, he remembered. Americans regularly decided great constitutional issues in ways that have profoundly affected what we have understood the Constitution to mean. A hard-fought struggle over constitutional principles culminated in the election of 1800, when Thomas Jefferson and his Jeffersonian Republican supporters defeated the Federalist Party of John Adams and Alexander Hamilton. Jefferson had blasted Federalists' unconstitutional exercises of federal power, which they said benefited the wealthy aristocratic class. And in response to the criticism, Federalists had passed a Sedition Act, making such false accusations punishable crimes. In effect, they tried to suppress constitutional politics outside of Congress. The Jeffersonian Republicans defended freedom of expression. They did not challenge the Sedition Act in the Supreme Court. They took the issue to the American people, and with their victory in 1800, mass-based constitutional politics became the rule. They won the constitutional argument in the court of public opinion, not in the courts. Now, Congress had no Supreme Court precedents at all to guide it when its members struggled over the admission of Missouri as a slave state from 1819 to 1821. They debated Congress's constitutional power to demand that Missouri instead frame a free state constitution. They debated Congress's power to bar slavery from the territories and whether states could forbid the entry of African American citizens of other states, as Missouri's proposed constitution did, and whether free black people were citizens at all. The resulting compromise of 1820 would not be tested in the federal courts for over 25 years, until the disastrous Dred Scott case. Amazingly, by modern standards, neither were state laws restricting African American immigration. Today, a law like that would be challenged in the court in a heartbeat. A generation after the Revolution of 1800, Americans decided a similar constitutional conflict over the scope of federal government power. A younger generation of Jeffersonians had enacted many of the same programs to develop the economy that their forebears had opposed. A national bank, national sponsorship of roads and canals, protective tariffs. And the Supreme Court had sustained the broad interpretation of federal power that such activist legislation relied on. But purists denounced these violations of Jeffersonian principles. In 1828, they harnessed the popularity of Andrew Jackson to gain power. And as president, Jackson vetoed the renewal of the National Bank's charter, vetoed road and canal building measures, and set Congress on the path to eliminating protective tariffs. And Jackson's ally and successor, Martin Van Buren, organized the Democratic Party to sustain these constitutional positions. And that's why all those platforms restated them over and again. And for most of the Democratic Party's three-decade-long dominance, public policy conformed to its positions. What of the courts? The Supreme Court did not have its own big marble building like it does today. It met on the ground floor of the Capitol in a small chamber that it inherited from the Senate. when the Senate moved on to larger quarters. And of course, it was a natural. The Senate was shaped like a court, acted like a court, so it was very easily transformed into a court. French aristocrat Alexis de Tocqueville exaggerated, therefore, when he reported in 1835 that, to quote him, "Scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question." It never happened with the protective tariff, a great constitutional issue throughout the 19th century, nor did the court weigh in on nullification. It did not address secession until after the question was settled on the battlefield. Tocqueville misled his readers when he said the courts were the institution by which the legal profession is enabled to control the democracy. Congress and the state legislatures were the institutions through which lawyers controlled democracy. All Tocqueville would have had to do was look at the inability of the Supreme Court to protect the Cherokee Nation from the depredations of their Georgia and Alabama neighbors in 1830 and 1832 to see how powerless the court was to counteract the will of a substantial majority. It was the job of government, especially state government, to provide protection of the laws. If the legislature and governor refused to do it, as in the case of Mormons, for example, there was not much the courts could or would do about it. You could either flee the state, as the Mormons did, as American Indian tribes did, and some number of free black Americans did. Or, as in the case of abolitionists who suffered from riots unprotected by the local authorities, as in the case of abolitionists and most black Americans, you could try to change public opinion. Until you did, you could not expect much help from the courts. Before the Civil War, the Supreme Court, like other courts, was not a counter-majoritarian institution. It did not see its business to be protecting minorities from majorities. The court's most famous, or rather infamous, effort to protect minority rights came in the Dred Scott decision, in which it attempted to secure the right of slaveholders to hold human beings as property in the territory of the United States. That's hardly what we think of as protecting individual or minority rights, and the effort failed. So how were individual and minority rights to be protected in a society without a counter-majoritarian institution to do it? By majorities themselves. In 1849, the great Chief Justice of the Massachusetts Supreme Court, Lemuel Shaw, refused to rule Boston's segregated schools a violation of the state's Bill of Rights. The proper province of a Declaration of Rights and Constitution of Government, he wrote, is to declare great principles and fundamental truths, to influence and direct the judgment and conscience of legislators in making laws, rather than to limit and control them by directing what precise laws they shall make. Of course, it took longer and was more difficult than having judges enforce the Constitution. Yet, only 6 years after Shaw's decision, an anti-slavery Massachusetts legislature passed a law desegregating schools throughout the state. Ohio, too, had oppressive black laws, as they were called, on its books from its founding in 1803, until Chase and his anti-slavery allies were able to repeal many of them in 1849. Even after that, black Ohioans were not entitled to public education until 1853, 4 years later, when Ohio authorized segregated schools for their children. In 1884, Ohio banned discrimination in inns, hotels, and similar public facilities. Only in 1887 did our state ban segregated schools. And all of this was done through legislation. None of it was done by the courts. In Chase's time, the Supreme Court's opinion were part of a conversation about what the Constitution demanded and forbade. They were part of a more general constitutional politics. The court applied the constitutional positions Americans were arguing in the political arena to specific legal controversies, restating them in the form of constitutional law. Their decisions and the opinions sustaining them were cited in congressional debates and constitutional arguments made out of doors. They were strong authority, issued, after all, by lawyers who respected the Constitution. But they were not binding authority. Chase devoted his career to persuading the American people to rejudge the decisions they and the Supreme Court had made to establish a pro-slavery Constitution. There were abolitionists who conceded that the Constitution was the pro-slavery document the court said it was. The Constitution was, in the view of the coterie of abolitionists around William Lloyd Garrison and his journal, The Liberator, a covenant with death and an agreement with hell. For the Garrisonians, constitutional politics consisted of trying to convince New Englanders to leave the Union that bound them to slaveholders. Other abolitionists took the opposite, the polar opposite position. They said state laws upholding slavery were unconstitutional. But most abolitionists conceded that the Constitution, even if viewed as an anti-slavery document like Chase did, left the question of slavery itself to the states. However, the Constitution did require the federal government to enact measures against slavery whenever it had the constitutional power to do so. In Washington, D.C., for example, in territories not yet states, on army bases, in interstate commerce. Chase phrased it differently. Having focused his constitutional fire on the fugitive slave law, Chase was more concerned with what the federal government could not do than what it could. It could not pass a fugitive slave law, he insisted. It was not among the powers delegated to Congress, and its provisions violated the Bill of Rights. Congress could not establish slavery in the territories. Doing so would be inconsistent with the federal government's purpose of securing liberty. He did not stress Congress's power to abolish slavery in Washington, D.C., as many abolitionists did. He denied it ever had the power to recognize slavery in Washington, D.C., because the national government was dedicated to freedom. Chase helped anti-slavery advocates organize the Liberty Party in Ohio. He wrote the constitutional planks of its platforms and prepared its addresses to the people, which reflected his constitutional ideas. And then they broadcast them around the country. And you can see at the top, circulate this document. Orders supplied at $1 per 100, a penny apiece. They will send you this document to circulate around the country. At the bottom, read and let neighbors read. So that you don't only read it yourself, you read it to your neighbors. Because he was more, let's see, I've got to find my place now that I got excited and left it. Because Chase was concerned with what the federal government, more concerned with what the federal government could not do to promote slavery than what it could do to promote freedom, he felt more of a kinship with the strict constructionist Democratic Party than with the broad constructionist Whigs. The Democrats also were the party of equal rights, while the Whigs tended to distrust democracy. If he could persuade Northern Democrats to extend the principle of equal rights to all Americans rather than to only white ones, it would be the natural party of anti-slavery, Chase thought. He thought there was real potential for this in the more radical wing of the Democratic Party. And in 1848, he saw his first real chance. That year, radical Democrats bolted their party's pro-Southern nominee to back former President Martin Van Buren for the presidency on a platform that supported a law to ban slavery in the territories. The bolt succeeded in electing the Whig candidate president, and in Ohio, it led to the election of enough anti-slavery Liberty Party candidates to hold the balance of power in the state legislature. Over the objection of most of their anti-slavery colleagues, Chase's allies made a deal with the Democrats. In return for repealing the deal gave Democrats control of the legislature In return for repealing the state laws that most egregiously discriminated against Black Ohioans, and in return for electing Chase himself to the Senate of the United States. In those days, senators were elected by state legislatures. And from that position as senator, Chase continued to articulate his anti-slavery constitutionalism and ultimately joined other anti-slavery politicians in organizing the Republican Party. 6 of the 9 planks of the first Republican platform of 1856 made constitutional arguments. 5 of those constitutional arguments were against slavery. Another explicit constitutional argument was in favor of funding federally funded internal improvements, and yet another plank backed construction of a continental railroad, which was a clear exercise of broad federal power. Again, of course, this is a Republican campaign edition for the millions of people. On its next page, it makes suggestions. A thorough knowledge of the Constitution is important to every citizen. Without it, no one can wisely choose men fitted for offices. Common men are competent to understand the Constitution. They ordained and established it, and surely common men are able to know what they meant by all its parts. Why? Well, first of all, because they believe in constitutional politics. Why also? Because the Supreme Court said all of this was wrong. It's not just the Supreme Court that knows the Constitution. Common men are competent to understand the Constitution. And when you vote for Republicans, you vote for an anti-slavery constitutional vision. Democrats reiterated their oft-stated commitment to strict construction. They insisted that the Constitution gave no power to Congress to interfere with slavery or take what they called incipient steps towards interfering with slavery, like banning slavery in the territories. The preservation of the Union under the Constitution, the Democratic platform said, was the paramount issue. And repudiating all sectional parties and platforms concerning domestic slavery was essential to that end of preserving the Union. So this was the kind of political rhetoric that characterized the entire Civil War era from the beginning of the anti-slavery movement through Reconstruction after the Civil War. It was constitutional politics through and through. When the Southern states seceded, it was, they claimed, because Northerners had violated the constitutional understandings that had protected their rights as slaveholders. During the war, Democrats blasted the Lincoln administration's infringements of civil liberty, its unconstitutional policy of drafting civilians into the armed forces, its invasion of state rights, and its Emancipation Proclamation. This was number 1 of the papers for the Society for the Diffusion of Political Knowledge, which is the institution Democrats organized to broadcast their view around the country. The Constitution, addresses by Professor Morse, that's Samuel F.B., the guy who invented the telegraph, strong Democrat. George Ticknor Curtis, one of the leading constitutional lawyers and practitioners in the country. And Mr. S.J. Tilden, a young lawyer from New York, who would ultimately be the Democratic candidate for president in 1877. When a party in power, that means the Lincoln Republicans, violates the Constitution and disregards state rights, plain men read pamphlets. Read, discuss, diffuse. Throughout his administration, Lincoln took special care to avoid letting a Supreme Court still dominated by Democrats review the actions of his administration. And the majority of the Supreme Court justices took equal care to avoid doing so. During Reconstruction, Democrats and white Southerners at first denied that the federal government had any constitutional power to impose conditions on Southern states as they resumed their place in the Union. Then they backed President Andrew Johnson's claim that he alone, as president, had the constitutional authority to impose conditions. Republicans spent immense amounts of energy discussing the constitutional base for congressional authority over the subject and for federal power to define citizenship and protect its associated rights. And they constantly worried that the Supreme Court would weigh in against them and took steps to warn the justices of dire consequences if they tried. As Chief Justice, appointed by Lincoln in 1864, Chase played the key role in making sure the justices did not interfere. And he finally was able to author a great opinion justifying the suppression of secession and recognizing federal power over Reconstruction. Now, in the end, Republicans wrote federal power to protect civil and political rights into the Constitution itself through the 13th, 14th, and 15th Amendments. And those amendments transformed the United States from a slaveholding republic that it was before the Civil War to the free republic that has unfolded since. The 14th Amendment really did more. It was worded expressly to encourage the courts to protect rights against state infringement, to take the job they had avoided under the pro-slavery Constitution. And the amendments embodied the decision Americans had made through constitutional politics and, one might say, through constitutional violence. Chase played an important role in all this. As Lincoln's Secretary of the Treasury, he took the lead in nationalizing the American banking and financial system. He reinstated the system of national banking that Jackson Democrats had destroyed. We still have a first, second, third national bank, the first ones that organized under the National Banking Act that he helped Congress frame. He was a persistent and public advocate for using the war power of the federal government to abolish slavery. He urged that Americans recognize the citizenship of African Americans and their equal civil and political rights. In 1864, some radical Republicans argued that he'd better represent anti-slavery principles than the more conservative Lincoln. Chase let them boom his name for the presidency. Lincoln was displeased, to say the least, accepting Chase's resignation from the cabinet. But when Chief Justice Taney died, Lincoln recognized that no one was better suited to incorporate anti-slavery constitutionalism into the law than Chase was. And that's why he named him Chief Justice of the United States, and he was confirmed by the Senate. We live in a different constitutional world now, one in which the Supreme Court has conceded a much greater role in defining the American Constitution and much more aggressively reviews government action to see that it conforms. We attend to constitutional law more than to constitutional politics. But it would be better if we understood that the Supreme Court is part of our constitutional politics and not outside of it. The Republican Party wants to have it both ways. It expects a more conservative Supreme Court to uphold, as a matter of constitutional law, what the Republican Party deems correct conservative views of the Constitution. It applauds when Supreme Court nominee Brett Kavanaugh insists that the justices are mere nonpartisan umpires who simply enforce the Constitution as they see it. But the Republican Party has engaged in a vigorous political battle to establish its views of the Constitution. Nominating Supreme Court justices who see the Constitution the same way they do has been central to that effort. They want the court to accomplish through constitutional law what the party has been trying to accomplish through constitutional politics. Now, insofar as Republicans are able to convince Americans that theirs is the correct conception of the Constitution, appointing justifies to apply that conception in law conforms to our long history of constitutional politics. An activist Supreme Court can push popularly endorsed constitutional philosophies beyond what the people conceived when they endorsed them. That's what the Warren Court did. But if an activist court tries to impose a different constitutional philosophy than the one that has triumphed in constitutional politics, there will be a constitutional crisis. To avoid such a crisis, it would be well to make constitutional philosophies explicit rather than implicit in our politics. However, it takes two to debate a constitutional philosophy. And while Republicans have been fulfilling that responsibility, Democrats have not. Anti-slavery lawyers and politicians like Salmon P. Chase spent their lives building an alternative constitutional argument to the one that supported slavery. There is a progressive alternative to conservative constitutional philosophy. Liberals and Democrats ought to articulate that constitutional philosophy and give the American people the chance to decide what the Constitution enables the government to do and what it forbids. In fact, they fail their obligation to constitutional democracy when they neglect to do so. In the end, the Supreme Court will turn a decision made through constitutional politics into constitutional law. Whether they realize it or not, the justices need that guidance from constitutional politics. It's dangerous to encourage them to cling to the illusion that they have the final authority to determine what the Constitution means, by failing to bring those issues explicitly to the American people the way Chase and his anti-slavery allies did. Thank you.
Well, thank you so much. That was, when you finished, I was like, what? Keep going. So we have time for some questions, and we're going to use the microphone, so therefore, since we're recording the lecture this way, these will be picked up as well.
What would be the consequences if the president refused to obey the court order either from the Supreme Court or a federal court?
Well, of course, it depends, of course, on the nature of the court order. In general, the courts will be very careful not to issue an order to the President of the United States except in the most exceptional circumstances. The only time the courts have decided that question explicitly was in U.S. versus Nixon, and it occurred, as the court said, in the course of a criminal investigation, which it said was different than most ordinary circumstances. So in certain circumstances, the court will issue that order. It will probably not issue that order unless it feels it has wide-ranging public support for issuing it. We give the court way more credit for power than it actually exercises. The court exercises its power very carefully, normally in conformity with public opinion. President Trump is not a dummy. He knows this instinctively, and he, of course, is trying to undermine any kind of public support there would be by trying to make the orders that would affect him seem partisan. It's a very capable strategy. So I cannot predict what you say. It's up to the American people. And again, of course, these issues are now being made before the American people. The president is very capable of making an issue in a way that will sustain his ability to defy court orders. He is being sustained so far by a Republican Party that sees an advantage in sustaining him rather than otherwise. Democrats are trying to make this issue. As I said before, that's different than making a general philosophical issue to sustain their constitutional positions. Well, I guess not, but one cannot. I'm sorry that I just imagined that this was in light of present circumstances. And of course, it's present circumstances that make the issue salient.
Go ahead.
Sort of a follow-up to Rob's question. I'm old enough to remember when the Brown versus Board of Education decision came down and Eisenhower was president. And there was a period of time when there was a question of whether he would enforce that. And he made a statement that I will obey the law of the land. But it strikes me that that it wasn't so obvious then as it is now that the Supreme Court dictates the law of the land.
Well, I think that's correct. I think it's the constellation of events around the civil rights movement that made the Supreme Court what it is today. It was the Southern governors were ready to defy the orders of the federal courts. And the question was, would the federal government use the power and the force that it had to support those court orders? It was not absolutely certain that it would do so, but it's very difficult to see how you would enforce federal law in areas where you think it is appropriate to enforce it against opposition if you don't enforce it in areas where you're not so sure. President Eisenhower didn't decide to enforce the court orders because he approved of desegregation. Far from it. He decided to enforce them because if he didn't, other people on other issues would engage in the same resistance, and you would not be able to have a federal government that enforced its laws.
Thanks. This is a follow-up to a follow-up, and I'll name it Trump. Presuming that Trump is found guilty of at least obstructing justice and all the other sorts of things that he's doing, if he decides that I'm just not going to resign or allow myself to be impeached, I'm just going to sit here like a big old toad in the White House, what constitutional remedies do we have to physically extract him from the office after he's been found guilty?
Well, first of all, you're conflating several items. The president may or may not be able to be indicted while he's sitting as president. The dominant view is that he cannot be indicted while sitting as president, although it's only a custom. There's a lot of evidence that Prosecutor Mueller does not think that you can indict a president of the United States. We don't know for sure, but there's evidence. And that is, by the way, the rule of the Department of Justice under which he operates, and therefore he cannot change it. What he would do if he thought that there was strong grounds to believe the president committed a crime would be to take that matter to the Congress and report it for impeachment, as Prosecutor Starr did with Bill Clinton. It is conceivable that he would take another choice, and that would be to indict a president, but that doesn't mean you have to try the president. Almost certainly a sitting president cannot be tried on an indictment, but maybe he can be indicted, and maybe that would be grounds for impeachment. Impeachment is quintessentially constitutional politics. The framers intended it to be constitutional politics. They didn't create an independent commission or tribunal to try impeachments, whether it was president or judges or anybody else. A person has to be impeached by the House of Representatives, a political body responsible to the people of the United States, and he has to be convicted, or she does, by the Senate of the United States on a 2/3 vote, a body elected and responsible to the people of the United States. All of this will play out, if it does, it is presently playing out, in the realm of constitutional politics. It's going to be up to the American people to decide what their Constitution means, whether an argument is certainly going to be made that a president must be limited by law and by norms and by the institutions of the government, and there's going to be an argument made that that is not so when the institutions are controlled by an illicit dark state. It's going to be up to us. It's not going to be up to what procedure or what instrument. If the American people make a decision, the institutions of government will carry it out. If the American people decide that they don't want those things to be carried out, they won't be carried out. Though we can all sit here and contemplate what that would mean for the true Constitution of the United States, but it's the people who make that Constitution and who have to support it or not.
I have degrees both in education and in law. I've always been curious about a particular amendment. You cited one, the 13th Amendment.
The 13th.
Which essentially says slavery shall not exist except by being committed a crime. Which suggests to me that that is not an amendment to abolish slavery. A guy named Douglas wrote a book. It's called Slavery by Any Other Name. he says in his book is that slavery actually existed well after the Civil War, and actually on up through the Second World War, especially within the South. Because what was happening is that blacks, African Americans, were constantly being arrested for trumped up crimes. What's your take on that?
Well, I think that's absolutely true. First of all, the 13th Amendment is very careful to state that slavery shall not exist except for people duly convicted of crime, which creates the opening for the system that we ultimately got, which was a system in which African Americans were disproportionately and unfairly convicted of crimes, sent into prisons where their labor was utilized without pay and then for minimal pay, and that still continues today, by the way. All around the United States, states rent out their convicts to private companies to produce private goods on behalf of those companies, which are then sold on the open market, without the convicts who are producing those goods being paid the minimum wage. Usually they are paid something. There's no real reason to imagine they would have to be prepaid anything. So that comment is absolutely true.
Just one short follow-up. It's your comment about constitutional politics as opposed to constitutional law. What is your take on the approach of constitutional politics to address that issue?
The problem with that issue, it's a whole other talk that I'd like to give here someday. The problem with that issue of misusing conviction for crime to reinstitute slavery is a problem of enforcing the 13th Amendment. The 13th Amendment, it says that neither slavery nor involuntary servitude shall exist in the United States except for persons convicted of crime. And then the second section of it says Congress shall make laws to carry out the foregoing section. It doesn't say anything about the courts. It's very difficult for the courts to enforce the 13th Amendment because by its terms, it states a bunch of rules. Surely, if you try to hold somebody as a slave without convicting them of a crime, a court can issue a writ of habeas corpus. But there's not much a court can do to tell a state not to institute this system. It was up to Congress to do that. And until this time that I'm talking about, as you can see implicit in my talk, it was legislatures and governments, not courts, that protected and defined rights. Courts weren't expected. That's why the 13th Amendment gives Congress the authority to protect the rights. The 14th Amendment changes this in reality, even though possibly not in intent, because it was worded explicitly to give the courts the right to tell the states what to do. It says no state shall deprive any person of life, liberty, or property without due process of law. If a state does so, it violates the Constitution, and it's normally the courts which intervene when the state does something unconstitutional. The fifth section of the 14th Amendment says Congress shall have the power to carry the foregoing sections into effect. The author, John Bingham, intended Congress to retain the same power it always had and to add the courts. That's not the way it turned out. One of the things that has happened is that we rely on the courts to enforce the Constitution. And the consequence is that Congress's power to intervene in any of these areas is very attenuated. And the courts have made it worse by purposely limiting congressional power to do these things once it got enough power to make its view known. So it's very difficult to deal with this problem. I would argue, and a number of more radical lawyers would argue, Congress ought to act. And then we'll see whether the court will say that a congressional enactment to enforce the 13th Amendment in these circumstances exceeds Congress's power under the Constitution. We'll find that out.
But just a little bit of follow-up because of the strikes that are going on now in the prisons and kind of tying that in, the hunger strikes that are going on right now.
Right. Who are the prisoners addressing that to?
This is what I'm trying to ask you, is I think
That's right.
And I think that's where it comes back to the will of the people and how many people
That's right.
can be persuaded.
These arguments have to be made in our politics. You simply cannot rely on the courts the way that we have. Very understandable why we did in light of the civil rights era and the record of the Warren Court and the earlier Burger Court. But these are decisions for the American people. And if you don't articulate them, if you don't pick up on these strikes and publicize them and talk about them, they are not, the rights of those people are not going to be addressed. It is politics. It's dangerous at first to pick up on those rights. You can be accused of being coddling crimes. But of course, 20 years ago, you could be accused of coddling homosexuals. 50 years ago, you could be accused of coddling Negroes. These issues have to be brought to the people. Trust the American people. Sam and Pete Chase trusted the American people. It takes time. Trust the American people.
In our pathway from Neanderthal to Nirvana, how indebted should we be to the Constitution compared to chance or some of the mechanisms?
The Constitution, I think, is the instrument by which the American people sought their nirvana. I don't think you can separate the two out. They came out of a context of British politics in which all British politics were perceived as constitutional politics. All British politics were perceived to be about the rights of the British people. It was an era in which British radicals felt that their system was being undermined and that their rights were being taken away by a parliament that no longer was bound by the Constitution. That was not just Americans' views, it was British views. Americans took that radical British view and made it central to our system. We said in our Declaration of Independence that all people are entitled to certain kinds of rights, and we created a Constitution that in its preamble said that the government of the United States was created in order to protect the liberties and secure and the security of the American people. That's how we envision things. One of the sentences I left out of this talk was the mistake I thought that many people make about treating equal rights, gay rights, women's rights, African rights, as human rights. They are human rights, but in America, human rights are channeled through the Constitution. In order to make them effective, they must be constitutional. They're much stronger if you can argue that they're constitutional rights. It's not irrelevant to argue for human rights. It can be a powerful argument in politics. But if you can argue that the Constitution is designed to do certain things, that the spirit of the Constitution calls on you to do them, in America, that is the powerful argument. It's also a powerful argument against doing those things.
Okay, I think we're at our time, and I want to let's all thank you for a wonderful talk, and thank you for answering all our questions.
Great pleasure. Thank you.